Sponsored by the law offices of Joe Pippen. Learn more at attypip.com.
Ask an attorney about Florida law. Ask an attorney, just give him a call.
This is Ask an Attorney, all about Florida law with Attorney Joe Pippen. If you have a legal question, call Joe right now. In Tampa, call 813-287-5700. Anywhere else, toll free at 877-943-9673. That's 877-943-9673. The law office is open. And now your host, Joe Pippen.
Hey, good morning. Welcome to Ask an Attorney, all about Florida law. I'm Attorney Joe Pippen, practicing attorney. The law office is open. Hey, is there any way I can help you this morning if you have a legal question? Or maybe it doesn't even have to be a legal question. It can just be a problem you need somebody to talk to about. The law office is open, and we're glad to be here and glad to be of help and service to you if we can. You have a toll-free number, 877-943-9673. That's 877-943-9673. A question can be about wills, trust, probate, guardianship, power of attorneys, personal injury, family law, real estate law, just a problem with a neighbor, problem going on in your life and you need someone to talk to. Be more than glad to try to help you. Again, the phone lines are open, 877-943-9673. And in studio to help me answer some questions today and also to talk about some topics, we have attorney Bob Bible. Bob Bible. His formal name is Robert. He practices in Clearwater, Florida. And we have a caller already, but just tell us briefly about your background and education and a little bit about you.
Well, it's great to be on the show. I'm happy to participate and provide whatever input I'm available to give. I grew up in Ohio and went to undergrad and law school in Ohio, and then what brought me to Florida was to get a master's in law in taxation. So traveled down 75 to Gainesville and got my legal master's in tax law, and from there started practicing in Tampa. And since 2014, I've had my solo practice, Bob Bible Law.
All right. Well, it's great to have you on the show today.
Thank you.
And we just personally met for the first time this morning as I picked Bob up. But he's a Christian brother, so, I mean, that's real special and one of the reasons he's on the show with me today. And I'm going to ask you a quick question before we take our – we've got 3 callers already lined up, so we're going to be a busy morning. What are they going to reduce the exemption to from 11.6 million to what? What's your guess? I know we don't know. Is it going to be 5 million? Is the one I hear the most, but
yeah, if I had the insight on that, I'd. But right now, and it's really impacted the way that estate planners, in terms of tax planning, have changed their practices. When I first started, the exemption was $600,000.
Right.
So now with the 11.6, plus you have what's called portability, which means you can double that with spouses. I'm not sure. I really don't have an answer to that. It's really hard for an
estate planning attorney. I knew I'd start you off with a difficult question. It should be easy from now on. Now let's go to Ian in Clearwater. Hey, Ian.
Hey, thanks for taking my call.
My pleasure. What can we do for you?
Well, I live in a condominium in Clearwater, and I own it free and clear. It's paid off. I went online, looked at the Condominium Act, Florida law, Chapter 718, and everything that flows from that. The problem is we don't have a board here. We're supposed to have a board of condo directors. As you all know, your attorneys, condominiums are governed by Florida law. Our property manager association will not return our calls, will not respond to our emails, will not respond to our voice messages. He suspended the elections last year. So we don't have a board of directors for a condo association. And he's ruling his place as an absolute dictator. Mm-hmm. So I need help, and I don't know where to begin, so that's why I'm calling.
All right. Well, thank you for calling. What I would recommend to you is when you've done everything, and my general answer to this type of question is when you've done everything you possibly can do yourself and you don't have a good result and doesn't seem like you're headed for a good result, then you need an advocate. And there are many attorneys that specialize in condo law that if I were you, I think I would get a group of people to sign a statement that'd be willing to contribute, toward the cost of and then interview several condo attorneys. I could, if you want to contact me off the air, I can give you a couple of ways maybe to find a condo attorney. And then you be represented and force them to do what they're supposed to do under statute. I mean, there should be escrow funds for roofs, and gosh, we just had a big condo collapse. I mean, so there are a lot of things to worry about. I'm sure that's got a lot of people thinking about the very similar question you have. Do I have an adequate board? Are they doing the proper thing? Are they doing the inspections they require to? So, Ian, I would recommend that we help you, or you find a condo attorney.
Do you do condo law?
No, sir, I don't. No, sir, I don't.
Okay.
But I can try to help you find an attorney if you want to contact me off the air. That's what you need. And you need a group of people to support your decision in moving forward.
Well, we've already got the group going. We're already working on that, and that's in progress. And,
all right. Well, that's what you need to do.
Yeah.
You need an advocate now to fight for you, because you've done what you can do yourself, and you're stuck. So you need an advocate. All right.
Okay. How do I get a hold of you up there?
All right. So the office number is 586-3306, and you just go to extension 200.
586-3306.
Extension 200. Yes. Mm-hmm.
It sounds like Largo number. Okay.
Yeah. Well, I have like 15 offices, but that's my headquarters office is in Largo. Yes. All right.
Okay. Can I call now or call on?
No.
Monday?
Yeah. Call on Monday.
Okay. I will.
All right.
Thank you.
All right. Phone lines are open at 877-943-9673. 877 toll free 943-9673. Let's go to Michael in Sarasota.
Hey, so I'm not quite sure all the legal things you can cover. So my dilemma is 2 weeks ago I brought my first son into this world.
Well, congratulations.
He has a problem. Hey, thank you. So he's been diagnosed with being tongue-tied, having a problem suckling. So we didn't do a hospital birth. We went through a midwife, all natural. They came in and, they do their evaluations. So they actually reported us to CPS for him not suckling, and they were concerned about his digestive system and all that stuff. So now we're dealing with the whole CPS issue. They're asking us, it's a 50-50, so they're telling us that we need to let him go with somebody else so he can be evaluated by a forensic pediatrician. Now, my question is, I really don't want to let my 2-week-old son go with strangers, and I'm afraid that if I say that I'm not okay with that, what are they going to? What's the ramifications? What's my stance? What can I do about this? He's perfectly fine. He's suckling. He's through the past week. He's even though he's a little tongue-tied, he's still suckling and eating and making bowel movements and all this stuff. So I'm just wondering what my stance is if I say I'm not comfortable with allowing my 2-week-old son to be taken away by perfect strangers, basically.
Well,
and we can't even go. So they're telling us that he's got to be taken away by other people. We can't go. We can't follow. We can't be there. So I'm majorly concerned.
Well, I think you've asked me a question I've never been asked before. In the 37 years or so I've done radio. So I'm kind of thinking through what I would do. So what I think I would do is do you have your own doctor that has examined the baby?
Oh, yeah. Yeah, we have a pediatrician. We're set up to have his tongue tied, rectified, fixed, and we're set up. And so we have, extreme documentation of everything that's going on. I'm just concerned that
Well, what I would do,
I'm not comfortable.
No, what I would do, I think, if I were you, I would have the doctor put together a written plan of action that you are going to follow, and have whoever is trying to force this on you say, look, I have a doctor. Here's his name. Here's his business card. He has a plan of action for the best health for my child. I'm going to follow that plan, and I don't need your services. And I guess Department of Children and Family could be involved in somehow or another. They could probably get involved, but I think you need a plan and tell them here's yeah.
I'm sorry.
Yeah,
I
go
didn't
ahead.
mean to cut. We're under investigation by CPS.
Well, I think if you show them that you have a plan and you're taking care of it and the child's okay and the doctor says it's okay and this is what the doctor wants me to do and this is what I'm going to do, I don't need your services. I'm providing for it myself.
Okay. I just, I'm concerned that when I...
Yeah, well, I would be too. I would be too. So you probably also, just like the first, you need an attorney advocate also on your side that can intercede quickly, that you've got set up to intercede quickly if the worst happens and then come take the child. I can't imagine they would do that if you have a doctor and a written plan of action and you're following it, though.
And on top of it, his mother, she's a nurse. So she understands the jargon. She understands the entire operation and the concern and all. I'm just afraid that...
Well, I'd probably have an attorney. I'd have an attorney. If you want to be really proactive, I'd have an attorney right away, right? Send them a letter that, this is what we're doing and this is the action we're taking. We have a plan of action.
Okay. So that I wasn't sure if I needed to be represented.
Well, the safe answer would be yes. And if the not so safe answer was show who's threatening you, your plan of action by a doctor, and that you're taking care of it. But the safe answer would definitely have an advocate attorney on your side.
Yeah. Okay. I appreciate you taking my call. I appreciate your words of wisdom.
All right. Well, very good. I wish you the best.
Everyone hey, thank you. You guys have a good day.
Thank you. Let's go to Diana in Sarasota.
Good morning, and I try to listen to you every Saturday getting ready for work, and I did come and have you do my will and my end-of-life choices. Okay. So, great fan of yours. Got a question that you probably haven't had before, just like this past gentleman.
Be three in a row. That'd be unusual. I said there'd be three in a row. That'd be unusual.
Yeah, I think you'll find this kind of interesting. Had a situation. I woke up on Monday morning after 4th of July and noticed some things awry outside of my home. And I live in a manufactured home community, wonderful management, wonderful owners, great neighbors. Everything's good. I thought a raccoon was out there and went outside to find that there was a man laying in my driveway, and that by all visual evidence had apparently tried to get into my home through a window. So, of course, I called the police and called an ambulance, and I'm terrified. And so then when he was taken care of, the deputies told me that they would be making no report, and they consider this a medical issue, not any type of trespassing or attempted breaking and entering, because he did not get in my home. And so I again, yesterday spoke with the deputy, got just out of concern about this. I'm like, I'm a little concerned. And they said, does it make any difference what it appears someone was trying to do, enter your home, or if they got in your home, if they are having a medical episode, in this case, an alcoholic, if they're having a medical episode, that is more important than anything else. They can't prove intent, of breaking and entering or coming in to steal from you or kill you, have what. They just see a medical issue in front of themselves, and that's all they do. That's all they take care of. And so this person lives in my community, and that concerns some of us here, that should this person do this again, the police just come and say, oh, he's having a medical episode, we're going to take him away for that. And so we kind of feel like he's welcome to come on our property, come in our home, and the policeman did say once he's in my home, I'm welcome to defend myself. But I'm not looking to get this man charged with trespassing, or I'm concerned.
All right, so you want peace of mind. You want to go to bed at night and have peace of mind, right?
Yeah, and know that.
All right, so here's
I
I do have a suggestion for you.
Okay.
You do have the option of getting a restraining order.
Oh.
So you can go to court and judge, tell them the circumstances, and you tell them you're very fearful. This man tried to break into your house. The police came, and he's sleeping on your driveway, and you're very fearful that he's going to try again because you called the police, and you're in fear of your life, basically, and your possessions, and you want to have a restraining order where he can't come on your property within so many feet, probably 150, 100 feet.
Okay.
Bob,
Thank
do you have a suggestion for? I'm going to start asking you if you have any input to help me out with some of these questions.
Yeah, similar to, I believe it was the first caller, where they're talking about home ownership issues where there might be an association involved. Association is generally a nonprofit corporation which has bylaws, rules, and regulations. So there may be some grievance procedures that might be within the association bylaws or rules and regulations. I'm not sure if this might even be a situation for a Baker Act, to try and have the person taken to where he can be evaluated by medical professionals to see if there might be something that requires hospitalization. But the restraining order, I think, is probably...
Seems like to me the police should have done something.
I
you have
agree.
a drunk person in your driveway. Yeah, trespassing.
Yeah.
They should have done something. I think I'm not trying to criticize the police here, but I think they could have thought of something to do to give you a little better peace of mind that we can't do anything because it's a medical issue. And the medical issue was a drug addiction, basically, or alcohol addiction.
Yeah.
I don't know. I give the police a D- on that one.
Yeah. As I said to them, two things can be true at once. There can be someone here that needs medical attention, but he was obviously attempting to break into my property, and they said they really can't do anything unless they can prove intent, and they can't really prove intent if he's having a medical issue. I appreciate the information you've given me.
All right.
That's
All
great.
right.
I feel like the managers here or the owners of the property will do everything they can, but within their legal rights, there's, I'm imagining their hands are tied too. Somewhat, that they have, often the perps are more protected than the victims. We know that.
Well, you can maybe suggest to the community association they put up cameras on some of the light poles or something for safety for the community.
We have them.
Okay. All right. Well, great.
We have them. It's very protected. It just happens to be that he happens to live here. So.
Well, do you have? Can you go get film of him trying to break into your house?
I don't know if there's one pointed at my house, and I will talk with management next week about all of these. That's what I was trying to get, all the ideas that we can do as a community, not to necessarily harm this man, but to give us more sense of peace of mind.
Whatever you do might help the man,
Right, exactly.
Right.
And I'm all for that. But I don't want to constantly feel like he can come in my house or on my property and there's nothing I can do about it because he happens to be drunk at the time.
All right.
That's not okay.
All right. You have a great day.
Thank you for your service to us.
All right. Thank you.
You have a good day, too.
Let's go to Rudy in Sun City Center.
Yes, Joe. Thank you for taking my call. I'll try to be very factual without going into all of the conditions which made me do this to begin with. Because of certain concerns with a son, I helped finance a condo in Sarasota. And I purposely took out made him take out a mortgage on that, and I used a LLC that I have as the owner of the mortgage.
Did you create the LLC? Did you create the LLC yourself?
Yes.
I'm going to have Bob ask you some questions about your LLC here in a minute, but go ahead.
Okay. And in any case, he started. He was paying payments for a while, and then he stopped when he hooked up with a siesta key type girl, almost the bimbos, just like you see on TV, but whose father and mother are both noted doctors in the area. A lot of money. But in any case, and there was some drug problems on her end, heavily involved. But in any case, he started spending money on her, stopped paying the things, and got behind on his condo, stopped paying property taxes that he was obligated to pay, and then subsequently must have borrowed money from the father of the girl, and they put a lien on the condo.
Well,
of course, that was.
Well, they have a judgment. They have a judgment against him, or the judge against.
I don't think there's any judgment. I mean, it's just a lien.
Was it a mortgage? I mean,
yes,
because a mortgage is a lien.
I
Okay,
put up original mortgage, and it's recorded.
All right, but there's a second mortgage on it.
Well, I don't know what that exactly means.
Okay, well, who owns the condo is in an LLC, so who is 100% owner of the LLC?
100%. I own it 100%.
So your son really had no authority to sign a promissory note because he was not an owner of the LLC. All right, but go ahead. So, what's your question? Okay, let me narrow down to your question here.
What I want to do is, I want to repossess that property, and I want that the parents of this girl with this drug issue and stuff. I can't blame any one of them, but I want to repossess that property and then resell it. I got to get off from underneath it.
Okay, repossess the property. You already own the LLC 100%, so you own the condo. So your question is, how do I? You have a mortgage. So
I put a mortgage on it intentionally when he signed to buy the condo.
Yeah, but you're still the owner. But you're still the owner, or the LLC is still the owner. So your real question is how to get rid of this the secondary lien or mortgage on the property.
Right.
So you'd have to contest that. Whatever that is, you're going to have to contest that was an invalid lien.
Okay.
So you're probably going to need an attorney for that.
Okay. Well, if that's the case, then I probably would want a recommendation about who.
Yeah, I can give you a recommendation.
Yeah, but there was a second piece of this, and again, once I started, I guess like a plot of parents, they get led down this path trying to help. Well, when he didn't pay the property taxes, they put it up for tax sale, so I ended up paying the taxes off. Mm-hmm. That was a problem. And then he didn't pay the condo association, and of course he lied about all of that.
Let me ask you this: is there a written agreement somewhere that since you're the owner of the LLC and the LLC owns the condo, is there a written lease agreement, or is there some written agreement that he has a right to live there, provided he make all these payments? Is there something in writing regarding that?
He's got a mortgage with the monthly payments on it.
But I don't understand how he could have a mortgage on it when you own it. I think you need to sit down with an attorney and let an attorney look online and see what the ownership is, what the mortgage is, how everything is structured before you're going to really get any good advice. I mean, we're just stabbing in the wind here of trying to figure out what you have, and it doesn't really make too much sense to me that you own it and he has a mortgage on it.
Well, me being the bank, the mortgage company.
All right. I still think you're going to need an attorney to look at all this. I'm going to have Bob ask you a couple of questions, though, to see if you have a valid LLC.
Okay, thank you.
When you look at when you set up this LLC, you went on to Sunbiz and just filled out a form online?
I went on to the I'd have to verify. On a mortgage document, it says the name of the LLC or my name. It could be that LLC or my name.
Okay, but looking at the LLC, in order to have a valid limited liability company in Florida, you actually have to file what are called articles of organization. And you can either do that through an attorney where they file it with the Department of State, or you can go online, and the online site with the Department of State is called Sunbiz. And they actually have pull-up forms that you fill in the blanks to do that. So did you go online, fill in the blank form, and then submit it with the cost, or how did you actually create your limited liability company?
The limited liability thing was created in Arizona.
In Arizona?
When I was living there.
Okay. So you have an Arizona limited liability company that bought Florida property?
Well, it in the purchase agreement, it indicates the son as the purchaser, and the mortgage placed on by my name or this LLC.
No, but this property is in your son's name now. It's not in your LLC name.
Correct.
What county is the property located in?
Sarasota.
Hillsborough. Okay, so go on to the Hillsborough County Clerk's. Do you have a parcel ID number for the property?
Yeah, I do. I can go.
All right, go into the Hillsborough County Clerk's website, do a search, put in the property ID number, and you should be able to pull up the deed. Or you can even do that through Hillsborough County Property Appraiser's office and find out who the actual owner of this property is.
All right, Rudy, so let me close this off now, though. But so it sounds like your son's the owner, not the LLC. And what you own is the mortgage on the property that you or your LLC or both own the mortgage. So to answer your question is how do you get the property? You're going to have to foreclose on the mortgage. You're going to have to hire an attorney to foreclose for you. And with that, I want to go to my next caller, but that's the answer.
Okay.
All right.
Thank you very much. I appreciate that.
All right, thank you.
Help a lot.
All right,
you
thanks.
Got somebody like you can recommend?
Yeah, I could recommend somebody to a foreclosure attorney. Just give me a call.
Okay.
All right.
Thank you. Bye-bye.
Let's go to Randy in Orlando.
Hey, good morning. How you doing today?
I'm doing great, and you?
I'm doing good. Thanks for asking. First of all, thank you for your ministry. I appreciate that.
Oh, my pleasure.
I got a question. Hopefully you can answer this. I live here in Florida. I'm originally from Wisconsin. My father had passed away. My brother was the executor. So I got two brothers and one sister. One sister's been estranged for quite some time now, and she's off in Maryland. And she found out about my father passing away, and she had flown down. And we had some instances in the past where she just really had a lot to do with when she did come back. It was about money. So we figured that would be the case. But we're like, hey, you know what? It's her father. Come on down. Let's hopefully we can make this relationship right. So anyways, my parents didn't put her in the will at all. No money or anything going to her. But came to where my dad was slowly passing away with bone cancer, and he wasn't all there. He was there, but not really. So anyways, what happened was she kind of talked with my dad privately because, brothers and I were in and out because we were inside of his home taking care of him. So we had to go out and do things. And she went ahead and talked with him. We didn't know. We got knocking on the door the next day that one of his lawyers came over, and they went to the basement. They were talking, came back up, and the will was changed. And so what had happened was my dad had put her on, with the house and with any property. So I'll sum this up. So what happened was that that was changed. Okay, so when we sold the home, she was able to get money from the home and any of the property inside of the home, like any type of bric-a-brac, painting, stuff like that. Well, she came to find out that there was stuff left for the brothers with Roth IRAs, with their actual bank account, and said, what was my name on these? We're like, well, no, your name wasn't on anything. It wasn't on any of the bank account. It was only us three with the Roth IRAs and other investments. That was under our name, too. She goes, well, don't you think I should get some of that? I'm like, well, if you were going to get some of that, then maybe Mom and Dad would have put that in the will. So we think right now she's going to try to fight this, saying that if he changes his mind on this situation, right, with the home and with the bric-a-brac and stuff like that, that he most likely would have, change his mind on these items. Where would we stand on this? Is this something like it's really a slam dunk for us, or no, she actually has a case?
Well, I'll comment and let Bob comment because I'm not sure we haven't talked too much together about things like this. So my answer would be the IRAs and accounts with co-owners. The will has nothing to do with those, and they would automatically go to the people named as a beneficiary on the IRA, or the co-owner would automatically get that. It has nothing to do with the will. The will, It sounds like, how long ago did your father die?
A year.
The most common challenges to wills are undue influence and incompetence, and it sounds like both of those may have been existing at the time your father changed his will.
Right.
So if she,
well, that's what we think.
Yeah. So I think you have to have an attorney prove all that, which is a long, drawn-out process most of the time, and you wind up in court trying to prove that. Well, it's pretty easy to prove he was incompetent if you have two doctors say he was incompetent at the time he signed the will. Undue influence, you take depositions, and if she was there and influenced him to change it, and she's the one that called the attorney and made all the arrangements to sign the will, and it was all in her presence, and the prior will for a long time said something else, that might be easy to prove. But the main question you asked me about the IRAs and the, other accounts outside of the scope of the will, which they would automatically go to those people.
Okay, so she would have nothing to do with that. Now, if it was inside of the will, it'd be a different story. But outside of that, no, whoever named, whoever.
Well, if it was governed by the will, you probably have an argument for undue influence or incompetence or both.
Right. Okay.
Bob, do you want to add anything to that?
Well, the term that's very common in most individuals' minds is probate. And so the reason why they call it a probate proceeding is that a will governs probate assets. Those are generally assets that through some other mechanism don't have a means of transfer at death attached to it. So when Joe was speaking of the IRA attachment that determines who gets it at death is a beneficiary designation. If there are bank accounts that have pay on death designations, or they were structured as joint ownership with rights of survivorship, those contracts control over the will. So even if a will says I give my IRA proceeds to my daughter, but the beneficiary designations under the will indicate I give them to my sons, then the beneficiary designations are going to control unless, as Joe indicated, there's some manner of undue influence or other wrongdoing attached to it. So if the beneficiary designations indicate that you and your brother are the beneficiaries, then that controls over the will. They are not probate assets.
Okay, so we're pretty good in that area.
All right. Well, hope we helped.
Thank you so much. You both have a great day.
All right, thank you.
Thank you.
Let's go to Paul in Tampa.
Hello.
Hey, Paul.
Yes. I have a question about gift cards in Florida. I bought a $100 eBay gift card for my girlfriend, and she tried to redeem the card, and on the call, they say that the code of the card doesn't exist. So I went back to the store, Winn-Dixie, and told the manager that there was a problem with the card, and he says, well, he can't do anything about it. And I said, well, the cards that you sell are activated on your cash register. Now, I don't. And also, the receipt says, let's see, it says no refund on card, all sales final. Well, he says it's not our responsibility. So, and then also on the receipt, it says for problems, call this 866 number, which is Winn-Dixie's headquarters. But they won't do anything about it.
Did you call the headquarters number?
I couldn't get a hold of anybody at that time.
So you have.
I guess I should. Is there any laws in Florida about gift cards in general?
Well, no. If they sold you a product for $100 and it's a gift card, they'd have to make good on the $100. They can't sell you a phony card with no value.
Right. Well, he's saying because it says on here all sales final, no refunds on card. Well, I asked him, I don't necessarily want a refund. I want another card because the one they told me was no good.
So who did you speak to? A store manager? The actual store manager?
Yeah.
Or just a manager?
That I don't know. There's two managers at the store.
I would go back to the store and say, look, I've talked to an attorney, which you have now, and the attorney said you can't sell me an invalid card, and I want to talk to your boss. Maybe he's an assistant manager. Maybe most grocery stores have pictures of all the managers and the manager, assistant managers, produce manager, so forth. So I would go back and say, look, I want to talk to the main manager. I don't want to have to go to small claims court to give for $100. You guys need to work with me on getting this made right. What's right is you sell them. I buy a card worth $100, and I go somewhere and try to use it. It's worth $100.
Okay.
And the worst case would be you have to go to the 800 number of the main Winn-Dixie office and voice your complaint. But, maybe you have to send them a receipt and the card back, send it certified. But it seems like the manager of the store, for goodwill, would want to work with you. Bob, do you have a different answer? Because I don't.
Well, I know that whenever you buy gift cards and you look at the receipt, the actual card number matches the card number on the receipt. They never actually see the security code. So unless your girlfriend maybe entered the card number incorrectly, or if somehow in the transaction at Winn-Dixie it was registered incorrectly, the card should be a product that you're able to return if it's an ineffective product. So
well, let me ask you this: can you use the card anywhere?
I'm sorry?
Can you use the card anywhere?
No, not really.
I mean, you have to use it at a particular store?
Yeah, it's an eBay card. You have to go to eBay.
eBay.
Place and redeem it. Then you can use it.
I see.
Where she entered the numbers and letters in the eBay system, and it said the card name and the code didn't exist.
Okay.
So I thought.
Can you print that out? Can you print that out and take that to the store?
No, not really.
You can't print out a notice that the card doesn't exist?
She gave me a picture on her phone that it didn't.
Okay, and you showed that to the manager at Winn-Dixie?
Yes.
Okay. Well, I would go back and see if you can talk to the main guy at Winn-Dixie, and then see if you get the same answer. And if the same answer is you have to go through headquarters, you might have to do that. At least you got a picture. All right.
Yeah. Okay. Thank you.
All right. Thanks. Phone lines are open. If you have a question, we have about 12 minutes left in the show. And you have a toll-free number if you want to call the show at 943. 877 is a toll-free number, 877-943-9673. And let's go to Don calling.
Good morning.
Hey, Don in Sun City Center. What can we do for you?
I wonder if I have a lawsuit or is there some remedy that I can go through? Last September, I filed bankruptcy. It was discharged in December. All the while, the mortgage payment or the house or anything had nothing to do with the bankruptcy as far as I was concerned. I mean, that was not in it. But I had a mortgage with United Mortgage, and Village Capital talked me into lowering my payment. It went from a 4-point-some to 2.75, and I thought that was a good deal. So in November, they said, well, don't make your November payment. Give it to us. We'll have a closing or a pre-closing on November 8th. And by the Thanksgiving of that month, they had not paid off the mortgage. And I'm just smart enough to realize nobody's going to be open here in the next 4 days. And I called them up, and a girl from Village Capital was just blubbering on the phone. She didn't know what or anything, or she didn't know anything. And sure enough, they didn't pay it off before Thanksgiving. They didn't pay it until December, causing me to have a 30-day late. I've never had a 30-day late on a mortgage payment. So now they want me to refinance again. I'm not doing that. I can't get a mortgage company to touch me with a 10-foot pole. Not only that, they had some kind of a rule or something. I had 30 days in December, or after the mortgage was discharged, to do something with them. I don't know what. So now I can't even get online to make the payment. I either have to pay the coupon or call them, which costs money every month, to make the payment. That's all I'm stuck with. I want to get away from a village capital as far as I can. I'd like to get another company, but the credit score, mortgage credit score, you have mortgage credit scores out there. It's like 578 or something. I can't get anybody to even look at me now. I don't know what to do. I want to do something. I don't want to call my payment in every month because that's the only way to make sure it's paid on the first. So what I really want to do is just sue Village Capital because they screwed everything up. They didn't tell me I had to do something within that month of December. I assumed I could just reopen another account online and pay it that way. I want to set up automatic pay, and I can't do it now. So where am I at? What can I do?
Well, you got a convoluted question there with a lot of moving parts. So I think the only answer, instead of me trying to dissect all that and point you in the right direction, is for you to deal with a attorney that can help you sort through there. And you said you did bankruptcy. I don't think the bankruptcy has anything to do with your mortgage if you were making mortgage payments, because you can file a petition to stay the payments or modify the payments during the bankruptcy court, possibly. But that didn't sound like an issue. So you need to refinance, and somebody was delinquent on doing what they should have done, causing you a 30-day late problem. So you guys to have an attorney maybe deal with that and rectify that. I don't know. The answer is like one of the first couple of questions there, you're going to need an advocate to fight for you, I think.
That's true. But that 30-day late really hurt me bad, worse than I thought.
Well, they might have some liability. They might have some liability there that an attorney can deal with. But
they try to placate me. So, we'll work on it. Well,
but see, you've done everything you can do yourself, so you need an attorney advocate to help you with it.
Okay.
All right. Wish you well, though. Best to you.
Thank you.
So, Bob, I want to ask you an LLC question. Does an LLC have to have its own tax number?
With limited liability companies, if you have a single member limited liability company, and when you have people that generally go online and form a limited liability company, it's oftentimes a single member. The IRS treats a limited liability company as what's called a disregarded entity. Basically meaning that it's similar to a sole proprietor. So you do not have to have a separate tax ID number, but I often recommend a separate tax ID number so that you can distinguish your business activities from your personal activities, plus anyone that would request with a W-9 a tax identification number for that business. You avoid having to give your personal Social Security number on that W-9, and you can give the federal tax ID number that you got for the entity itself. So I would suggest with a single member limited liability company, you get a tax ID. For multi-member, yes, you need a separate tax ID number.
Does a single member LLC offer any asset protection?
At one time it might have, but there was a series of cases which culminated in a Florida Supreme Court case that basically treated a single member limited liability company almost akin to a revocable trust, basically meaning if you can get at the assets, so can your creditors. So with a multi-member limited liability company, the creditor protection, and these are creditors for the individual owners, not dealing with creditors of the entity itself. They would be limited to what's called a charging lien, meaning they are only entitled to receive those distributions that you receive from the limited liability company. with a single member limited liability company, the Florida Supreme Court basically held that that's not adequate protection for creditors, and the Florida legislature enacted pretty much that ruling in statutes that indicates that a creditor has the ability to show that a charging lien for a single member is not adequate protection, and they would actually be able to take the limited liability company interest and foreclose on it to access the assets of the entity.
So can you take a single member LLC and add a 1% owner?
It has to be a legitimate, if you kind of look at the rule of thumb, 5% ownership is kind of what people use to make it look realistic and as a genuine transfer of ownership. Many times, if there are spouses involved and the business is owned by one spouse, they'll add the other spouse, or they'll even create a 5% interest as tenants by the entirety, so that they not only get the protection for that other interest through the charging lien provisions of statute, but they'll get the extra protection from the tenancy by the entirety ownership, meaning it would have to be a joint liability for them to even attach that 5% interest.
Can you convert a single member LLC to an S or C corporation?
There are check-the-box provisions that the IRS has where you can take an entity, even a multi-member entity. So if you look at a multi-member limited liability company, the default rules would be that it is taxed as a partnership. But because partnership owners have self-employment tax obligations, many of the multi-member LLCs will check the box to be taxed as an S corporation. A single-member limited liability company can do the same. So as opposed to being a disregarded entity, single-member LLC owner can check the box, be taxed as an S corporation, but that provides federal tax implications. It does not affect the liability issues at the state level.
All right, Bob, I'm sure I've stirred up some interest and concern for some of our listeners. How do they contact you if they want to discuss this further with you?
They can go to my website, which is www.bobbiblelaw.com, or they can contact me directly, 727-710-5166.
And if you didn't get all that, and you can just reach me. If you have my contact information, I'd be glad to share that with you and get you pointed to someone who can help you with your LLC or S or C corporation and make sure that it does what you want it to do. Let's go to our last caller, which is Ross in Largo.
Good morning.
Hey, good morning. We have about a minute, so.
Okay, I have a management company who stole all my files, so now I can't do business. I cannot renew leases and some contract. And I filed a burglary report.
Yeah, you're probably going to need an attorney to file a lawsuit for you as well. Because there you're going to need, that's, unfortunately, I hate to just give the answer you need an attorney, but, if I can help you, I will. But in something like that, you're going to have an attorney probably file a lawsuit for you.
Okay, thank you.
All right, thank you. All right, well, thank you for listening to Ask an Attorney All About Florida Law. We're presently on about 15 stations around Florida. We're broadcasting today from Tampa on 570, 910, 860, 930, and they all have FM components. We're Jacksonville, 600 The Answer. We're broadcasting from two stations in Sun City Center, 96.3 and 100.1 FM, and 90.3 FM out of Central Florida, Landmark's Voice of Faith station. Glad to be here. Join us every week at this time on Ask an Attorney All About Florida Law. There is a rebroadcast of this show on 570, 910, 5 p.m. on Sundays. Also, that's rebroadcast in the Sun City Center stations, also 96.3 and 100.1. Thank you so much for listening to Ask an Attorney All About Florida Law. If you'd like to call the office, toll-free number 1-800-226-3529. Emails at joe@attypip.com. Hey, Bob, thanks for being on the show.
I enjoyed it. I appreciate the invitation.
All right, thank you. Be safe.
proceeding is sponsored by the law offices of Joe Pippen. Learn more by visiting attypip.com.
Odyssey.
Strength Between Sundays. Faith Talk 570 and 910. Online at Let's Talk Faith.